Good morning, good afternoon, and good evening, everyone. And welcome, everyone, wherever you are. And welcome to today's podcast episode hosted by South Asia Research Institute for Minorities. And since this is the first time we are interacting with our esteemed guest all the way from Caribbean, from Trinidad and Tobago. So a brief introduction about what we do. SARIM focuses on addressing the challenges faced by minority and marginalized communities across South Asia, raising awareness about their struggles and advocating for their rights. My name is Furqan Ahmed, and I have the honor and privilege of moderating this session today, which is focusing on defending religious freedom and human rights. This discussion is very timely because we are discussing it at a critical moment when democratic values and pluralism are under pressure worldwide. And to speak on this topic, we have the absolute honor of having Dr. Honorable Justice Anthony Gafoor, who is the Chair and Chief Judge of Tax Appeal Court of Trinidad and Tobago, who is an eminent jurist, a scholar of international law, and a leading voice of mediation, arbitration, and interfaith dialogue. Justice Gafoor has written extensively on taxpayer rights, regional integration, and human rights, including his most recent book on jurisprudence, the jurisprudence of Caribbean Court of Justice and the regional integration in 2024. So thank you so much, sir, for joining us for the first time ever on our platform. And it's an absolute privilege to have your company with us. So with your introduction, a slight introduction, because our podcast is designed in a way that starts with your own journey. So let's walk us through regarding your entire journey and share with our audience like what motivated you to pursue a career at the intersection of law, human rights, and interfaith dialogue. Over to you.
That's all right. Thank you very much for the opportunity, and likewise, it's truly an honor and a privilege for me to be here and to share a few thoughts on what I think is not only a very topical but a very critical issue that I think we can see manifestations of throughout the world. Just briefly, in terms of my own journey, of course, it was really pursuant to an academic path in terms of reading law, and then, of course, developing an interest in not just the general area of human rights, but specifically the extent to which, there is that intersection, as you might say, with the law, human rights, and, of course, interfaith dialogue. And so it's really something that I'm not sure to what extent my background would have prepared me for, but certainly, coming out of the Caribbean and being, pursuing not only at the local or regional level, but elsewhere, my legal studies, I think I've been exposed considerably to the extent to which minorities have been, I would say, overwhelmed or even suppressed. And I think it's really something that triggered a great interest in me in terms of hopefully being able to make some sort of contribution towards that dialogue. So while my primary job is really a legal posting, a judicial posting, clearly there are areas that I have a deep interest in, not just because I've been exposed to certain things, but also because I've had the privilege of teaching some subjects that bear on, minority rights. So, for example, I've been a senior lecturer at the University of the West Indies in St. Augustine in Trinidad in several areas, including international negotiation, mediation, and international development and international law. And all of those areas, you might say, touch and concern, I would say, the key subject area of that intersection, between law, human rights, and interfaith dialogue. So it's been born not just out of my background, but also because I've had the opportunity to teach in some of these areas, as well as being involved as a researcher and a scholar in the field of regional integration. So all of these, I think, have, in a sense, come together to influence the extent to which I've been involved in some of these areas.
Thanks so much, Your Excellency, for expressing your journey and in comprehensive in giving us the comprehensive outlook of your academic, professional, and I would say personal, journey that you are holding. And it was an absolute pleasure, I must say, while having a short interaction with you in Seoul. So I really rejoiced that moment, and thank you so much for that.
Useful to have.
So to set the tone for this conversation, I'm slightly juggling with the questions. So instead of question two, I'm jumping on the question that is talking about the current rise in religious intolerance, right?
Yes.
So in your opinion, what do you believe are the most effective legal and institutional mechanisms for protecting religious freedom? With a special focus in diverse pluralistic societies such as those in South Asia, beyond, and perhaps in Caribbean as well.
Well, I would say that minority cultures and religions have to feel comfortable. They're not going to be subject to what is popularly referred to as the tyranny of the majority. And in many countries, including the Caribbean, there is at times some tension that may subsist between cultures, or among religions, all competing in many ways for some space in the public domain. With reference to Caribbean, I would say there are certain jurisdictions, including Trinidad and Tobago, Guyana, Suriname, which is pretty diverse in terms of having persons of both African and East Indian and Chinese and Syrian and other cultures. And we all subsist or exist, I would say, perhaps more accurately, fairly harmoniously. We haven't had any major religious warfare or conflict. Perhaps it's of a more subtle nature. Of course, in other parts of the world, it may be somewhat more pronounced, and you may degenerate into violence. There had been in some instances, for example, in the Cooperative Republic of Guyana, where you had some tensions between what was the Portuguese community and the Africans and so on. And generally speaking, there were riots. We've had some issues occurring in Trinidad and Tobago and so on, but really not on any significant scale that one might be overly concerned and so on. But in terms of the specific response to your question, I do think that resort to certain institutional mechanisms are critical, in particular having an independent court system, independent tribunals that deal with minority issues, whether in the religious or other domain. So if I can use as a point of reference Trinidad and Tobago, of course, at the national level, we have the court system, and of course, judges are appointed through a fairly independent process. But we also have other tribunals, for example, the Equal Opportunity Tribunal, and you do have maybe counterpart tribunals in other parts of the world. And their remit is very much to protect persons, especially if there's a sense of being discriminated against on religious grounds or some other basis and so on. So I think that the institutional mechanisms such as the courts and other tribunals that seek to uphold certain rights, of course, the protection of the Constitution as well, because we all have in this part of the world and in many others a written Constitution, many of which include certain human rights provisions, and those are supposed to safeguard and guarantee the extent to which someone who may feel discriminated against can resort to a constitutional motion or come before the relevant court or tribunal and seek some relief, and so on. So I think it's important to have a process whereby persons who staff these bodies are appointed and that they are seen to have the requisite skill and quality and independence to discharge their functions. And, we have seen in other parts of the Commonwealth an attempt to, in many ways, subvert and control the judiciary. I'm happy to say, at least in the Caribbean, I'm not aware of any such issues as such, but people have their views in terms of the effectiveness of certain judges or otherwise. But I would say as a whole, the judicial system is fairly independent and independent-minded when it comes to adjudicating on very sensitive issues, such as, religious discrimination and discrimination of other forms. So I do think that strengthening the judiciaries is critical. Sometimes there is, an issue of them being under-resourced, and I think that will hamper the effectiveness and so on. But I think if any country is mindful of protecting minority rights, it's important that the bodies that oversee the constitutional issues that may arise or other forms of discrimination should be strengthened and resourced adequately to be able to do their job properly. So those are some of the areas which I think are relevant in terms of ensuring that we can protect minority rights, particularly where there may be some instances of religious discrimination.
Absolutely, and thank you so much, sir, for guiding us through the possible, the outcomes or the possible, results that we can apply in terms of addressing these issues. So there is a follow-up questions, and I want your brief response on this. I often advocate that whatever the issues that you are facing, you have to knock the doors of your local justice system, right? So we often see the trend that instead of knocking the doors on our own judicial system, we see the activists and people from across the world often knocks the door of, international communities. So what is the purpose of behind this? Is this like lack of trust within the judicial system, or is it like, perhaps the exploitation element comes into play when if you understand what I'm trying to incline this?
Well, I think I'm not sure if I fully comprehend, but I would say that, one can anticipate that where people have different faith backgrounds or different cultures, there's always likely to be a lack of understanding and the competition for, space. And for example, we celebrate virtually all of the major religious festivals in Trinidad and Tobago and many of the other Caribbean countries and across the globe. So, for example, when you have Diwali being celebrated within the Hindu community, the whole national community joins in, and often their greetings at the highest levels from the president and prime minister and other such officials. Similarly, when it comes to celebrating, Eid or other celebrations within the Muslim community or Christian celebrations as well, and we have several other religions which also have their own special season, we find that the entire country joins into it. In fact, it's one of the things I often miss when I'm away from Trinidad and Tobago from time to time, that we have, I would say, a significant level of harmony, which is not to say that you don't have the odd tension. So, for example, there's a tradition whereby the government of the day would offer some level of sponsorship and financial support when these various religious groups celebrate their special occasions and so on. And of course, some have more than one. Christian community, of course, celebrates Christmas, but then everybody else celebrates Christmas as well. Or we have Corpus Christi, which is a special day devoted to the Eucharist in the Catholic Church and so on. But I would say that everybody tends to join in. Sometimes there may be an issue in terms of funding and who gets how much and so on. But generally speaking, I think it's important that you have the door open for dialogue and discussion. I think one of the issues that leads to conflict, not just in this part of the world, but in other parts, is the fact that people are not talking to each other. Or I would say that you may have some governments and other those in authority who may encourage, some level of tension among communities, whether to remain in power. Of course, or because they think that this is something they may favor and so on. If they belong to a particular group or tribe or whatever, that collective may be. So that is always unfortunate, because I think it's important that, people can try to live harmoniously. I think we have enough on our plate all over the world, and so therefore we shouldn't have religious tension, but it does exist. And so I think the important point is that there has to be a process for dialogue and discussion. And I find that often when people can come together through a mediator mediated settlement or a process which involves an experienced third party, sometimes it can help them to see and appreciate each other's viewpoints. And that can often, result in hopefully a positive resolution. Sometimes, as we've seen in parts of the world, warfare breaks out on religious grounds. And I think it's always unfortunate. I mean, you can go back to the time of the Crusades, for example, in Europe, when you had tension between the Islamic and the Christian communities and so on, centered around the recapture of certain lands that were occupied by Christians and subsequently by Muslims and so on. And there are several other examples historically where you have this religious tension that has subsisted. But, very often, I think, as we often say in the sphere of mediation, sometimes an opportunity to meet and discuss and even apologize for past misgivings, I think, is important. I mean, we can look in more modern times at movement towards seeking reparation for slavery, which is, while it's not necessarily a religious issue, it has given rise to a lot of concern as to whether those countries that have benefited from the slave trade in the past would seek to make some level of reparation or offer some compensation to those countries that have been adversely affected by such unfortunate situations such as the slave trade and so on. So I would say that, if we look at Trinidad and Tobago, for example, there are various areas where we can see that the courts and others have sought to intervene when it comes to easing the tensions that sometimes will flare up and so on. And I think it's important to keep a positive approach when you deal with such conflicts.
Yeah, the positive approach should be the key in addressing these issues. And thank you so much, sir, for comprehensively addressing this question. Just last follow-up question, then we'll move to another point of questions. Your comments on building the capacity of religious leaders and faith leaders who are unaware of those legal systems and activism. So what would be the message, like your approach in addressing this capacity building?
Well, I think a heavy obligation rests on the state to ensure that there's education and sensitization to ensuring that there is some level of religious discussion and dialogue, not just in the sphere of discrimination against religious groups, but also in general. So, for example, I had the privilege of sitting on an institution here in Trinidad and Tobago called the Mediation Board for over a decade. And what I would find is that very often those who were seeking to be certified as mediators would come to be assessed. And many of them were religious leaders. And I always thought that was very, very heartening, the fact that they found that it was important to embrace what mediation could offer. Because naturally, if you're a religious leader, people would tend to come to you to resolve conflicts, whether of a fairly minor nature or perhaps something that is more serious. And I think that religious leaders should take the lead in this regard, because I think it's, people do tend to respect them and automatically tend to seek out their assistance when it comes to the resolution of conflicts. So I would say greater sensitization to the use of mediation. Apart from the formalized systems I've mentioned, such as the court system, I think is important. One of the unfortunate things is that we live in very litigious societies where people seem to think that the first port of call when you have a dispute is to rush off to the court system. But I do think that insofar as, the use of third-party intervention, such as mediation and perhaps more formal systems such as arbitration, may be very, very helpful in terms of ensuring that you can have somebody assisting you, especially when it comes to community disputes or other areas of conflicts, where there can be that level of intervention. But I think parties also should be encouraged to negotiate with each other. And unfortunately, if that doesn't work out, then certainly to have resort to mechanisms such as mediation and other related areas, to where you may have an experienced third party helping to guide the parties along whilst retaining their neutrality and so on. And we see this at the international level, unfortunately may not have worked very successfully at the moment in relation to what is going on between the Israelis and the Palestinians, or of course to a different extent what's going on between Russia and the Ukraine. But we have seen instances in the past where conflicts that have been characterized by religious tension have been successfully resolved through mediation. And for example, I can point to the Good Friday Agreement, which was arrived at back in 1998, in Northern Ireland, where you had tremendous conflict, going on there between Britain and the Republic of Ireland, and being played out in Northern Ireland, where there was significant loss of life and damage to property. And yet still the parties were encouraged and able to come together to address what was initially perhaps a religious issue, but also there were the more fundamental matters there. So that level of third-party intervention through mediation can work if we trust the system, if we are willing to talk to each other. I think that's a problem. People often discontinue or not open to communication because they regard other parties as being their enemies and so on. There have been various other historical examples. You can look to what had taken place way back in the mid-70s with the Camp David Accord between, Israel and Egypt under the auspices of President Carter of beloved memory, and the extent to which you can see certain political leaders intervening and ensuring that where you have religious tensions, they may be able to play a role in encouraging the protagonists to come together and talk to each other.
Yeah, thank you so much, sir, for such a detailed discussion over the first part of our podcast, which was perhaps linked towards the mediation part and the religious intolerance. So this is for the experts who are working on the intersection of physical justice and the democratic governance and human dignity. So in your experience as a chief judge of tax appeal court, and who has been working and has written on taxpayer rights as human rights, how do you see the link between fiscal justice and the broader framework of democratic governance and human dignity?
Well, I think the concept of democratic governance is both an ideal and also something that we hope would be a reality as well, because sometimes the democratic process can be challenged by all sorts of issues occurring. But I would say that traditional human rights have tended to touch on several areas, particularly things like civil and political rights on the one hand, or economic, social, and cultural rights. And of course, while all these are important, I think increasingly, we can see developments internationally towards recognizing a right to development. And that subsists particularly when it comes to countries that have been under colonial rule and have demanded over a period of time not only their independence, but their desire, fueled by assistance and so on, to be able to chart their own destiny globally. And of course, that applies to the Caribbean as well as other countries. Now, in relation to fiscal rights, I think in more recent times, we can see this as a subset of the broader human rights discourse, because one of the problems has been that, taxes, for example, are collected by state authorities, generally speaking. I mean, you may have some local councils or authorities which may have the right to also collect that, but most of the time when it comes to direct taxes, such as income tax or, other forms of taxation, or indirect tax, such as value-added tax or customs and excise duties, those are collected by state authorities. And taxpayers, and I think we're all taxpayers in one way or another, have to feel that they can not only access the justice system, but also that they can have a fair hearing when they come to have their matters discussed, not only at the administrative level, but at the judicial level. So in my own involvement in this, which I have been for several years, one of the issues that is often raised when matters come to the courts is the idea that persons have not had a fair hearing when they've dealt with some of the revenue authorities. And they do expect and hope that the court system will be, staffed with persons who will not only give them a fair hearing, but also entertain their concerns. Of course, I would say that it's a question of really maintaining a level playing field, because to some extent the state authorities may also be aggrieved and may feel that taxpayers have come up short in various ways. But, for example, in the systems that operate in the Caribbean, a heavy onus is placed on the taxpayer to be able to disprove an assessment to tax. And so, therefore, that person has the initial burden to discharge, but of course, there may be a question of evidence which has to be brought before the court or tribunal to ultimately resolve the matter. And I have found that in many instances, when parties, both state parties and private parties, come to court and they start talking to each other, they will very often resolve matters themselves, but they have to have the forum to do so. And I think that is what the court provides, because while courts ultimately will give a decision, and if parties are unhappy with it, they may take it further on appeal and so on. I do find over the period of time I've been, having the privilege of being involved as the chief judge of this court, that when parties do come to a particular forum, they often find that dialogue may lead to them resolving matters themselves. And we're all about encouraging that. I mean, where they haven't been able to do so, of course, we have frequently been called upon to render a decision, and I think that that is, I suppose, how many courts should operate. But I do think that the need for dialogue, whether through the court system or privately with a mediator or other dispute resolvers, is important. Because very often you have parties, for example, that deal with each other on a very frequent basis. And you want to ensure that there is some level of them being amicable towards each other and so on. Sometimes there may be some grudges or issues that may occur. But in general, I would say, particularly in smaller countries, smaller societies, parties and people know each other, and it's important to encourage them to talk to each other as well. But I do think that taxpayer rights have now been very much recognized as a type of human right, or form of human right, because we're really talking about getting a fair hearing. We're talking about natural justice, where someone has not felt that they've been properly heard or been afforded a proper audience. And sometimes the court can intervene and, in fact, even order them to talk to each other. Ultimately, if they can't resolve it, of course, we are here to assist them. But I think that taxpayers, and some of them from the private sector, and I'm talking, for example, about multinational companies, have a significant impact on the economy of a particular state. So, for example, in Trinidad and Tobago and some of the other oil and gas countries, now we have Guyana, Suriname, and others, they've been engaged in major exploitation in the oil and gas sector. And that exploration is often carried out by some of the big multinationals. And sometimes they may prefer to resort to arbitration, whereby they can hire, in effect, a private judge. But we've had several energy cases come before the courts. And while sometimes they become a little prolonged, we find that, generally speaking, they do seem to be willing to work towards an amicable settlement in that. And then the energy sector is quite critical to many of the Caribbean jurisdictions, and indeed around the world as well, too. So certainly the impact of multinationals is important. And I would say we also have the smaller taxpayers who are able to access the rights and maybe have a more informal process whereby they can talk to each other and hopefully come to a resolution.
Absolutely. Thank you so much, sir, for your response to this. You've rightly indicated some of the key aspects of like tax right as human rights. So there's a follow-up question. What are the mechanisms being followed in order to enable those multinational companies to pay more taxes? So, I mean, because a lot of the taxes have been employed over the informal sector and people like us, right? So, how would you be able to bind them to get them convinced that, like, you are the ones who are getting lots of fruits of the economy of our country from ABC country, right? So, how would you bind them to come into the frame of taxpayer zone?
Well, we find that in many instances involving a foreign entity or other companies and so on, documents or treaties such as bilateral or multilateral investment treaties are critical. And very often they have clauses or provisions in there which encourage parties to negotiate or to arbitrate a dispute. So that by reference to those documents, we find that, which of course have the force of international law, we find that sometimes they very often suggest ways in which parties can resolve matters themselves, and of course, ultimately to come before the court system. So I would say when you're dealing with foreign entities of that level, some of the multinationals are very, very powerful entities that, the growth and the economic strength that they have sometimes may even outweigh the economies of smaller jurisdictions. It's important to ensure that they both respect the rule of law, but also that they respect the clauses that they've entered into, which will often provide a mechanism for resolving disputes. And we see even at the regional level, we have the Caribbean Court of Justice that has an important role to play within the region itself, because it's not only a body that exercises an original jurisdiction, so it's a first port of call with certain types of trade disputes, but also in relation to being a final appellate court for 5 out of the 15 or so CARICOM, jurisdictions, which is the movement towards greater regional integration. The Caribbean court and, of course, domestic courts have to work in harmony with each other when it comes to resolving issues of community law, when it comes to resolving international disputes that may be encapsulated within an energy treaty, for example, or international treaty. So it's important that you have persons with the requisite skill, knowledge, experience, and so on, who can assist those who are opposed to each other in resolving those disputes. So I think building up a repository of well-trained persons, mediators, judges, and so on, can instill confidence that if you have a conflict arising, for example, between a multinational and the state, which will often raise investor-state disputes, you have the means by which that skill can be provided, and so on. Sometimes, as I've mentioned, parties may choose to go the route of arbitration, where they may bring in effect, their own judges. Of course, ultimately, those judges have to resolve matters independently of the parties. But the point is that there are provisions often in these treaty arrangements which will allow for persons to engage in negotiations and ultimately to resort to a more formalized system where necessary, and so on. So I think it's important to recognize that these sorts of documents should be properly scrutinized and drafted, so that you don't wait for a dispute to arise. You want to ensure that you think ahead. And many of them have standard provisions, of course, which encourage a process to allow parties to negotiate and ultimately to go to a more formalized system where necessary.
Thank you very much, sir, for responding to this question of getting them into the window of taxpayers. So I'll move to another session, which is mediation and interfaith dialogue. You have somehow gave us the prelude about of this theme. So, Your Excellency, you have taught and practiced mediation exclusively, right? Could you share with us an example where interfaith dialogue or mediation helped prevent escalation of tensing or safeguarding minorities, tension between safeguard minority and their rights?
I mean, we have several helpful examples. One that I think springs to mind is where you may have a majority religion that may seem to dominate in particular country, and of course, which is often challenged by minority groups. So several years ago, we had a dispute over what was the highest national honor or award that was distributed at particular times of the year. Now it's when the country celebrates what we call Republic Day. Used to be Independence, where you had the highest honor referred to as the Trinity Cross, named after Trinidad and Tobago, and of course ultimately Trinidad and Tobago was named after the concept of the Trinity in Christian religion, Catholic religion. And that was challenged by, I believe, a Hindu group in Trinidad and Tobago, which had maintained that, for example, it was not appropriate for someone, should they be bestowed with the highest honor, to be given something called the Trinity Cross, which was quintessentially a Christian concept. And the court system had held that, in fact, there was that level of discrimination through the naming of that award, and that it should be renamed. Well, it ultimately was renamed as the Order of Trinidad and Tobago, a far more neutral term, which is, of course, also used in other Caribbean countries, such as Jamaica, where they also have the Order of Jamaica and so on. And so it's important that minority groups have the opportunity to challenge things that are almost a given, even if they have been accepted for several years. We've had other instances where, for example, marriages were not recognized within the Hindu and Muslim communities and so on for several years. And in fact, it took not only legislation, but protests and other processes to ensure that the state could recognize as valid certain marriages, within other, I'd say minority communities. So I think while Trinidad and Tobago, for example, started off life very much as a Christian country, and I think, of course, Christianity is a major group, we've seen some of these other religious groups agitating for recognition and for respect. Another example I can give is the educational system, because very often when persons came to be exposed to the educational system in the, I would say, colonial days and even in the post-colonial days, that those education opportunities were extended primarily to persons from certain backgrounds, Christian backgrounds, for example. And we found that the Presbyterian community from Canada came to Trinidad and Tobago and tried to assist those of East Indian descent in the more rural areas and so on to be able to be well educated. Many of them, of course, have blossomed into very esteemed professionals in this society and other societies. We've also seen that, for example, in the Hindu faith, they've started, and in fact, over several years now, established schools that have done extremely well in terms of results and grades and so on. But previously, they had been condemned and really thought as being some way inferior to some of the Christian schools. Nobody, I think, can say that now, because by virtue of their results, they have even outperformed many of those education institutions, certainly at the secondary and so on. And many of those students go on to perform very, very well at the local or regional university and even further afield. I would say that, in fact, we find that people of East Indian descent and so on have shone very well. Of course, we have others who have done well from other religious groups and so on. But I would say that it's important that everybody has a voice. And sometimes that voice has been drowned out by virtue of political factors, by virtue of economic factors, and so on. And I think we have to be very, very careful that everybody is given the opportunity to be heard. If you denied having your voice heard, this is often where a major conflict can occur.
Absolutely. And thank you so much, sir, for enlightening me or us for giving some of the examples of those intriguing stories coming from Trinidad and Tobago. I really was surprised to hear the aspect of the acknowledgement of marriage among Muslims and Hindus, and this was really something new for me. So talk about the regional integration and human rights, which remains a key theme in your scholarship, sir. So in what ways can institutions like your own institution, which is CARICOM, or the Caribbean Court of Justice, contribute to strengthening human rights protection across the region, and perhaps other legal entities as well, like international legal entities?
Sure. Well, I would say the movement towards greater cohesiveness and regional integration started back in the 1960s, 1970s, where many CARICOM countries felt that there was a need for closer unity and cooperation. So CARICOM is an acronym which means the Caribbean Community. And so that process started some years ago, has now blossomed to something called the Caribbean Single Market and Economy. And one of the problems is that it did not have enforcement mechanisms. It did not have, for example, a regional court that could insist that certain community disputes be referred to it. So, for example, and again in the field of taxation, where you had one CARICOM country imposing taxes on importations from another CARICOM country, something called the Revised Treaty of Chaguaramas, which was signed back in 2001 ensures that by establishing a regional court, you have now a judicial mechanism that can help to intervene and assist to resolve those sorts of disputes. But inevitably, as in Europe, you have many disputes that have spilled over, throughout the religious and of course, economic communities especially. And we find that many of the movements that have taken place in the Caribbean are very much reflective of what has taken place in Europe with the establishment of what was the European Economic Community, and then subsequently, through the European Court of Justice and other mechanisms, an opportunity for adjudication. So the one factor that was missing from the early days of regional integration attempts was the lack of a judicial mechanism. Now that we have this since 2001, and I would say it was formally, inaugurated in 2005, we have a process whereby forms of discrimination can be addressed. So, for example, the court exercising what they call an appellate jurisdiction, not just the original jurisdiction of trade matters, has often adjudicated on significant criminal matters and constitutional matters. One such example is the preservation or otherwise of the savings clause. Now, savings clauses have subsisted for many years since independence, and in fact, even into the current time, where the colonial laws have been preserved and really cannot be interfered with. But in more recent times, you've found that the Caribbean Court of Justice, and indeed even some of the domestic courts, have identified the fact that if savings law clauses result in some form of discrimination or breach of human rights, they would seek to intervene and possibly to even disapply those clauses and so on. So the protection of human rights has really been seen as a more important process than simply the preservation of laws which could work in injustice. And I think, again, pointing back to the court system, pointing back to other groups that have often agitated for the change of laws, it's important that people and groups talk to each other, listen to each other, and so on. But the savings law clause has been a very contentious issue in the Caribbean. And there have been more recent cases where some of those issues have spilled over into the public domain. I think it's also important to recognize that within the Caribbean, we have not just what is referred to as the English common law tradition of jurisprudence, but we have other countries from the Dutch Caribbean, from the French Caribbean, and so on, that have slightly different systems of law, particularly the civil law codes that have been brought in from Europe. So, for example, in land disputes, which we've had several over the years, in Guyana, for example, and indeed in Trinidad and Tobago, you've had instances where those land disputes have been prolonged for many, many years. In relation to Guyana, for example, they operated what is now the inherited system of the Roman Dutch system of law. And the Caribbean Court has been quite creative in ensuring that it can refer to those jurisdictions in, for example, South Africa, which have operated on the Dutch system to resolve the land disputes that have occurred there and so on in Guyana. And of course, we have other jurisdictions in Lucia and elsewhere where you have the French code, of course, inherited from Emperor Napoleon and so on, where there's been a need to pronounce and so on through that local court system. So the Caribbean Court principally governs disputes that have occurred, I would say, among some of the common law jurisdictions, but you have had others that have been thinking seriously about coming on board. Suriname, for example, operates on the Dutch system of law. Guyana, you have a hybrid of both common law and civil law systems. And so it's important that the judges are well equipped, well aware of both systems of law that operate throughout the world, especially the common law and the civil law. And I would say that you've had other instances where persons have felt discriminated against on the basis of the criminal justice system. And again, the courts have been very creative in terms of how they interpret the Constitution. They've resorted to the Caribbean Court has used the preamble to the Constitution to ensure that it can be used as an aid to interpretation where there may be no clear-cut answer in terms of how to resolve certain constitutional disputes.
Thank you so much, sir, for again enlightening me on this topic. I really wasn't aware of those intriguing facts and figures that you just quoted on the theme of having integration within the CARICOM and other Caribbean Court of Justice. So we're just moving to the closing of this session today. So I'll talk about regarding your book, which examines the jurisprudence of Caribbean court justice. What, in your view, is the most significant judgment from the court so far in advancing human rights or religious freedom, and why?
Well, the book, which came out, in fact, earlier this year, really speaks to the question of regional integration and the role of the Caribbean Court of Justice. And I'm happy to say it's available, internationally through Amazon and other websites. But one of the significant issues that has arisen in terms of pronounced on regional integration, and we sort of discussed this, has been quoted with Dr. Ramstad, who is present on the link, is the fact that, to sort to articulate certain key areas of law. So, for example, in Barbados, you had the operations of the Mercy Committee. The Mercy Committee is the last port of call where somebody has been, subject or is subject to the death penalty. It was thought for many years, I would say, that the work of the Mercy Committee was immune from any sort of judicial intervention. But in a famous case called Joseph and Boyce, the Caribbean court made it very, very clear that procedural fairness must apply even to the work of the Mercy Committee. We've had, for example, other significant decisions coming out of the Caribbean court and other national courts, one pertaining to cross-dressing. So, for example, the saving law clause had operated to cause certain persons who were cross-dressers in Guyana to be prosecuted under all laws going back to 1893. And the Caribbean court made it very clear that the savings law clause there could not be tenable because, those laws not only interfered with your fundamental rights, but also, should not result in somebody being prosecuted and so on. It was a fundamental right to be able to dress. I think the court there said it was as natural as breathing and so on. So those are two specific examples, I would say, where some of the jurisprudence that has emerged regionally and, in fact, discussed in the book, have shown how important courts can be where necessary in intervening, where persons' human rights have been, or dignity, I would say, have been adversely impacted upon.
Thank you so much, sir, for explaining some of the insights of your book and the findings of your book. And once again, it was an absolute pleasure of having you. And apologies for the earlier intervention of the internet, which was hindering us to have that intriguing discussion that we had, today. And before I close this session, I would like to say my hello to a person who has been silently waiting in this conversation with Dr. Indira Ramprasad, who I would invite her to say a few words regarding the discussions that we carried out today.
I prefer not to turn on the camera, but good morning. It's good to see you again. It was so far away when we met in South Korea a long time ago. Well, not a long time ago, but a while ago. Yes, this is an interesting discussion. I couldn't hear very well. I don't know if Justice volume was up to maximum. It was very soft on this end. But interesting discussion in the end there with regard to the CCJ and human rights and the jurisprudence. What I don't think he mentioned it is Shanique Myrie. That is a landmark case. And although it was not a human rights case, there were human rights issues which could have been addressed had the matter been brought to the appellate jurisdiction of the court. In that she was subject to body cavity searches while traveling from Jamaica to Barbados under the CSME, Caribbean Single Market and Economy, which allows hassle-free entry to any Caribbean territory for 6 months. So I think we would need to look at that for those who are interested to look at that matter in particular because it made waves in the region. Although it was not decided upon on human rights, the young lady did win her case because it was a breach of her fundamental right to free movement throughout the Caribbean. So that's the only point I really want to raise. There was another one that was brought again through the. I believe this one was brought through the original as well. This was a young man of homosexual orientation. He was a lawyer traveling to Trinidad, and our archaic immigration laws didn't allow him it did allow him, except that he was arguing that we need to remove the archaic immigration laws, which are contrary to gay rights. And he was always allowed into the region. So the CCJ actually they dismissed the matter because they claimed that his fundamental rights were not infringed upon, although they also addressed the archaic immigration laws and made a recommendation that they should be repealed. So those are the kinds of matters that come to the court. It's not a human rights court in the original jurisdiction because it deals with free movement of persons, capital, labor, and all that kind of thing. In the appellate jurisdiction, it can deal with any matters that is brought to it from the lower courts. So the court is not a human rights court in its original jurisdiction, but it deals with such matters in its appellate jurisdiction. It's a dual jurisdiction court, which makes it somewhat unique in a family of courts.
Thank you so much.
That's my contribution.
Yeah, thank you so much, Dr. Indira, for bringing your insights. And on this note, Dr. Justice Anthony Gafoor and Dr. Indira Ramprasad, thank you so much for participating in this podcast session and enlightening us and our audience with the wealth of knowledge in regards to human rights, interfaith dialogue, and the power of having mediation or mediatory role. So thank you once again for providing the wide range, insightful discussion, ranging from taxpayer rights to interfaith dialogue and regional integration. Your reflections remind us that human rights are interconnected and must be defended across all dimensions of the society. Thank you so much. And on this note, we'll close on to this session.
Thank you very much. And of course, I'm very privileged to have had the invitation to be part of this discussion. And thank you very much for that opportunity. And of course, it truly is a pleasure and an honor to be here.
Thank you so much.